The Federal Reserve Act, Part 7. Bank Examinations. Section 21. Section 5240, United States Revised Statutes, is amended to read as follows. The Comptroller of the Currency, with the approval of the Secretary of the Treasury, shall appoint examiners who shall examine every member bank at least twice in each calendar year, and oftener if considered necessary. Provided, however, that the Federal Reserve Board may authorize examination by the state authorities to be accepted in the case of state banks and trust companies, and may at any time direct the holding of a special examination of state banks or trust companies that are stockholders in any Federal Reserve Bank. The examiner making the examination of any national bank or of any other member bank shall have power to make a thorough examination of all the affairs of the bank, and in doing so he shall have the power to administer oaths and to examine any of the officers and agents thereof under oath, and shall make a full and detailed report of the condition of said bank to the Comptroller of the Currency. The Federal Reserve Board, upon the recommendation of the Comptroller of the Currency, shall fix the salaries of all bank examiners and make report thereof to Congress. The expense of the examinations herein provided for shall be assessed by the Comptroller of the Currency upon the banks examined in proportion to assets or resources held by the banks upon the dates of examination of the various banks. In addition to the examinations made and conducted by the Comptroller of the Currency, every Federal Reserve Bank may, with the approval of the Federal Reserve Agent or the Federal Reserve Board, provide for special examination of member banks within its district. The expense of such examination shall be borne by the bank examined. Such examination shall be conducted as to inform the Federal Reserve Bank of the condition of its member banks and of the lines of credit which are being extended by them. Every Federal Reserve Bank shall at all times furnish to the Federal Reserve Board such information as may be demanded concerning the condition of any member bank within the district of the said Federal Reserve Bank. No bank shall be subject to any visitorial powers other than such as authorized by law, or vested in the courts of justice, or such as shall be or shall have been exercised or directed by Congress, or by either house thereof, or by any committee of Congress, or of either house duly authorized. The Federal Reserve Board shall, at least once each year, order the examination of each Federal Reserve Bank, and upon joint application of 10 member banks, the Federal Reserve Board shall order a special examination and report of the conditions of any Federal Reserve Bank. Section 22. No member bank or any officer, director, or employee thereof shall hereafter make any loan or grant any gratuity to any bank examiner. Any bank officer, director, or employee violating this provision shall be deemed guilty of a misdemeanor and shall be imprisoned not exceeding 1 year, or fined not more than $5,000, or both, and may be fined a further sum equal to the money so loaned or gratuity given. Any examiner accepting a loan or gratuity from any bank examined by him or from an officer, director, or employee thereof shall be deemed guilty of a misdemeanor and shall be imprisoned not exceeding 1 year, or fined not more than $5,000, or both, and may be fined a further sum equal to the money so loaned or gratuity given, and shall forever thereafter be disqualified from holding office as a national bank examiner. No national bank examiner shall perform any other service for compensation while holding such office for any bank, or officer, director, or employee thereof. Other than the usual salary or director's fees paid to any officer, director, or employee of a member bank, and other than a reasonable fee paid by said bank to such officer, director, or employee for services rendered to such bank, no officer, director, employee, or attorney of a member bank shall be a beneficiary of, or receive directly or indirectly, any fee, commission, gift, or other consideration for or in connection with any transaction or business of the bank. No examiner, public or private, shall disclose the names of borrowers or the collateral for loans of a member bank to other than the proper officers of such bank, without first having obtained the express permission in writing from the Comptroller of the Currency, or from the Board of Directors of such bank, except when ordered to do so by a court of competent jurisdiction, or by direction of the Congress of the United States, or of either House thereof, or any committee of Congress, or of either House duly authorized. Any person violating any provision of this section shall be punished by a fine of not exceeding $5,000, or by imprisonment not exceeding 1 year, or both. Except as provided in existing laws, this provision shall not take effect until 60 days after the passage of this Act. Section 23. The stockholders of every national banking association shall be held individually responsible for all contracts, debts, and engagements of such association, each to the amount of his stock therein, at the par value thereof in addition to the amount invested in such stock. The stockholders in any national banking association who shall have transferred their shares or registered the transfer thereof within 60 days next before the date of the failure of such association to meet its obligations, or with knowledge of such impending failure, shall be liable to the same extent as if they had made no such transfer, to the extent that the subsequent transferee fails to meet such liability. But this provision shall not be construed to affect in any way any recourse which such shareholders might otherwise have against those in whose names such shares are registered at the time of such failure. Loans of farmlands. Section 24. Any national banking association not situated in a central reserve city may make loans secured by improved and unencumbered farmland, situated within its Federal Reserve District, but no such loan shall be made for a longer time than 5 years, nor for any amount exceeding 50 per centum of the actual value of the property offered as security. Any such bank may make such loans in an aggregate sum equal to 25 per centum of its capital and surplus, or to 1/3 of its time deposits, and to pay interest on the same. The Federal Reserve Board shall have the power from time to time to add to the list of cities in which national banks shall not be permitted to make loans secured upon real estate in the manner described in this section. Foreign branches. Section 25. Any national banking association possessing a capital and surplus of $1 million or more may file application with the Federal Reserve Board upon such conditions and under such regulations as may be prescribed by the said board, for the purposes of securing authority to establish branches in foreign countries or dependencies of the United States for the furtherance of the foreign commerce of the United States, and to act, if required to do so, as fiscal agents of the United States. Such application shall specify, in addition to the name and capital of the banking association filing it, the place or places where the banking operations proposed are to be carried on, and the amount of capital set aside for the conduct of its foreign business. The Federal Reserve Board shall have the power to approve or reject such application if, in its judgment, the amount of capital proposed to be set aside for the conduct of foreign business is inadequate, or if for other reasons the granting of such application is deemed inexpedient. Every national banking association which shall receive authority to establish foreign branches shall be required at all times to furnish information concerning the condition of such branches to the Comptroller of the Currency upon demand, and the Federal Reserve Board may order special examinations of the said foreign branches at such time or times as it may deem best. Every such national banking association shall conduct the accounts of each foreign branch independently of the accounts of other foreign branches established by it, and of its home office, and shall at the end of each fiscal period transfer to its general ledger the profit or loss securing at each branch as a separate item. Section 26. All provisions of law inconsistent with or superseded by any of the provisions of this Act are to that extent only hereby repealed, provided nothing in this Act contained shall be construed to repeal the parity provision or provisions contained in an Act approved March 14, 1900, entitled, quote, "An Act to define and fix a standard of value, to maintain the parity of all forms of money issued or coined by the United States, to refund the public debt, and for other purposes, unquote. And the Secretary of the Treasury may, for the purpose of maintaining such parity and to strengthen the gold reserve, borrow gold on the security of the United States bonds authorized by Section 2 of the Act last referred to, or for 1 year gold notes bearing interest at a rate of not to exceed 3 per centum per annum, or sell the same if necessary to obtain gold. When the funds of the Treasury on hand justify, he may purchase and retire such outstanding bonds and notes. Section 27. The provisions of the Act of May 30th, 1908, authorizing national currency associations, the issue of additional national bank circulation, and creating a National Monetary Commission, which expires by limitations under the terms of such act on the 30th day of June, 1914, are hereby extended to June 30th, 1915, and sections 5153, 5172, 5191, and 5214 of the revised statutes of the United States, which were amended by the Act of May 30th, 1908, are hereby reenacted to read as such sections read prior to May 30th, 1908, subject to such amendments or modifications as are prescribed in this Act. Provided, however, that Section 9 of the Act first referred to in this section is hereby amended so as to change the tax rates fixed in said Act, by making the portion applicable thereto read as follows. National banking associations having circulating notes secured otherwise than by bonds of the United States shall pay for the first 3 months a tax at the rate of 3% per annum upon the average amount of such their notes in circulations as are based upon the deposit of such securities, and afterwards an additional tax rate of 1/2 of 1 per centum per annum for each month until a tax of 6 per centum per annum is reached, and thereafter such tax of 6 per centum per annum upon the average amount of such notes. Section 28. Section 5143 of the revised statutes is hereby amended and reenacted to read as follows. Any association formed under this title may, by the vote of shareholders owning 2/3 of its capital stock, reduce its capital to any sum not below the amount required by this title to authorize the formation of associations. But no such reduction shall be allowable which will reduce the capital of the association below the amount required for its outstanding circulation, nor shall any reduction be made until the amount of the proposed reduction has been reported to the Comptroller of the Currency, and such reduction has been approved by the said Comptroller of the Currency and by the Federal Reserve Board, or by the Organization Committee pending the organization of the Federal Reserve Board. Section 29. If any clause, sentence, paragraph, or part of this Act shall for any reason be adjudged by any court of competent jurisdiction to be invalid, such judgment shall not affect, impair, or invalidate the remainder of this Act, but shall be confined in its operation to the clause, sentence, paragraph, or part thereof directly involved in the controversy in which such judgment shall have been rendered. Section 30. The right to amend, alter, or repeal this Act is hereby expressly reserved.